Thanks, Harold. So, just resuming on the question of whose intentions matter and what the tribunal was finding in, I think, 132 to 135.
Yep.
At 132, the tribunal does go so far as to say that the question whether something is a punishment is found in the purpose of the person imposing the punishment. We don't go as far as that. We don't think they're the same question. We think that it is highly relevant what a body who's authorised to regulate or punish thinks they're doing, but we wouldn't say it would always be irrelevant what the person being punished thought. But when I say that last part, where you're offered alternative forms of punishment, your reasons for choosing one over the other, which may well be entirely commercial, and I think those are the reasons that you were taken to, I think, in paragraph 35 of this decision, why Scottish Power preferred to have redress payments made. Equivalently, in paragraph 70 of McLaren, the reasons why McLaren preferred to pay a large fine rather than be expelled from the competition, those don't tell you whether or not they understood it to be a punishment. Those are just reasons why they might commercially prefer one form of sanction over another.
Sorry, you did say, I think, that you do not say that the payer's intentions are irrelevant.
They're not. We don't say they're irrelevant. We don't think it goes quite as far as the tribunal said there. But it is an evaluation whether you can characterise this as having the nature of a punishment. We say a fair reading of the decision, particularly 132 to 135, what they go on to do is that is what they're finding. That isn't determinative, because the question isn't, the legal question is not, is this a punishment? It's, does it fall within the principle in McKnight? And I'd say there isn't scope to say this isn't a punishment. The tribunal's basically determined that. The challenge is because it isn't the statutory penalty, does that mean it didn't actually fall within the comments of Lord Hoffman in McKnight?
So what do you say that the FTT's findings that you say there were about the nature being punishment, what does that tell us about the answer in this case?
Well,
because you said it's not determinative. Well,
the statement Lord Hoffman made when he says, why does the particular character of final penalty? He says, this is, its purpose is to punish the taxpayer, and a court may easily conclude that the legislative policy would be diluted if the taxpayer allowed to share that burden with the rest of the community. We'd say...
He's not there talking about any individual entities' subjective
purpose.
He's talking about objectively legislative.
Yes. And I'd say, but your evaluation of that, as in this case, the first tier's evaluation of that, is going to be informed by whether it was right to call this, whether this was something which was imposed to punish the taxpayer, which is the phrase used by Lord Hoffman, and whether it would undermine that scheme, the scheme under which the regulator is acting, if the burden is allowed to be shared. I mean, that's what he's saying there. And so the question is, does that apply here on the facts found? And we would say yes. When you look at all of these settlements, most obviously the late one which have those letters, but also if you turn to tabs 10 and then 11 of the supplementary bundle, the first settlement, what you see is there is a prior discussion as to what the total cost to the taxpayer is going to be. So at tab 10, when Scottish Power are reopening negotiations with Ofgem about the mis-selling penalty, they first say, well, we emphasise that upper proprietary should be no more than 10.5 million. And then at tab 11, you have spoken to Ofgem again, they've agreed to come down to 8.5 million, which is what ended up happening. And so we say this is the same, this is less formal, but the same as those later cases where you have a letter setting you settlement options. And what is happening is you're being told what the cost of your infringements is going to be, and you then, together with Ofgem, decide how to divide that up. And so we'd say the purpose of this regulatory enforcement would be diluted if you could then share that cost, if by agreeing to make payments in one direction rather than another, you changed the burden of what the regulator was doing to you. Which would put another way, we'd say, when you're answering that question in McKnight, the fact that they took that second step, having agreed the total figure, to decide so much will go here, so much will go there, is just not relevant to the McKnight question of would it dilute the purpose of the regulatory sort of the regulatory structure if you let them share this burden.
Lord Hoffman expressed that as the rationale to explain Von Glenn, to explain why it is that fines and penalties aren't deductible. Are you, in a sense, converting that rationale into the actual rule?
I think if you look at Von Glenn, I would make the same submissions. This is what I said shortly before lunch, and I think in some way. But if you look at the way it's expressed in Von Glenn...
Yeah, but Lord Hoffman has told us, in a sense, don't worry too much about that, because the Court of Appeal...
Well, they're saying that if we are...
didn't do a good job.
If we don't need to worry too much about Von Glenn and just what Lord Hoffman is saying, then I'm happy with saying that that's if that's the whole of the rule, then I say this case falls within it. I'd say if it's an explanation of Von Glenn, this case is also completely consistent with Von Glenn, that the statements there about how this is imposed on the taxpayer out of his profits, not as a component of making the profits, or an unfortunate incident that follows after profits have been earned. The answer to that question wouldn't change in these cases, depending on whether or not, having agreed that there would be an 18 million penalty, they agreed or failed to agree with Ofgem what form of redress would be paid instead of it going to consolidated fund. And I think that it would be quite different if you started from a compensatory project. I was asked earlier about what if there is actual true compensation where there's a real claim. And the answer there is you might well have a situation where there are clear existing enforceable claims and the regulator is telling you have to pay up on those. That's not going to be a punishment. Because, I mean, paying a debt you already owe isn't a punishment. That would actually be closer to an example of, well, you've not been hiring enough people, you need to hire more people in future. It's just telling you to improve your standards of behaviour, which is one of the things the regulator can do. But where they've decided you're going to admit, if you admit breach, the sanction will be 18 million, or 8.5 million for the first one. And you then agree where those payments are going to be made, we'd say, well, the sanction is supposed to be 18 million. It would be diluted, and the dilution doesn't stop mattering because you're paying some of it to Scottish Power Energy People's Trust, or I think what it was called, or to the Warm Homes Discount Programme, because that's the amount that's supposed to be demanded of you. And then on the specific point of the distinction between the kinds of compensation, it certainly doesn't make a difference that of the 1 million pot put aside in the mis-selling, but just over half of it went to individual customers. It could have been more, it could have been less. The rest of it went to this energy trust. That doesn't affect the principle, what's basically going on here, and whether it infringes the dilution concern.
Can I just be very specific about what Lord Hoffman said, if you've got it open in front of you, on 337, page 180. At the bottom, which is the critical passage we've been looking at, he says that the reason, in my opinion, is much more specific and relates to the particular character of a fine or penalty. He says its purpose, which you could read rationale, is to punish the taxpayer, and a court may easily conclude that the legislative policy would be diluted, etc. Now, if you have a piece of legislation that enables somebody to impose a fine or penalty, the purpose that you're looking at is the legislative purpose behind that fine or penalty. If you don't have a piece of legislation which spells out that you are entitled to make all sorts of other orders, why does it defeat the legislative policy if those payments can be set off against profits or set off against income for determining your profits?
I would say that the legislative policy we're looking at here is not just the policy of section 27A, if I get it correctly, the one that actually imposes the penalty. It's the policy of the Electricity Act in creating a regulator with authority to punish. And that therefore... the
regulatory authority does all sorts of things. It's not there just to punish.
No, yes, it's several, but
punishment
that
is penalty. Which other bits of the Electricity Act you say exhibit or show that there is a legislative policy to authorise the regulator to punish?
Well, we would say it is the fact that there is a penal sanction, but these agreements are made in exercise of that power. They're not ultra vires. They are using their punitive function, and they have decided they are allowed to do that in a way.
So they have decided that they are allowed to. Which bit of the Act, which bit authorises the regulator to do that which you say is equivalent to a penalty, is a punishment, other than imposing the actual penalty under section 27A? Can you show me the statute?
Well, I think our position is that 27A1 allows a penalty reasonable in the circumstances of the case.
Yes, well, that was £1.
But where, as the tribunal assessed it, the reason it's £1 is that the parties have previously said there's this...
Sorry, but we're not arguing here about the £1. Where's the authority, the statutory authority, which would be undermined, or the policy behind the statute? Where's the statute that would be undermined by allowing deduction of the 17,999,999? Which bit of the statute?
Well, it would mean, I would say it is still 27A, because 27A authorises, 27A in general makes clear that the regulator has a punitive as well as a simply kind of guiding or guiding function, and that if it chooses, therefore, to use its punitive powers like this, and we know from what the tribunal assessed that this was a punitive exercise, turning a £18 million sanction into, I suppose it would be about a £15 million sanction, but still, which would also depend on what the kind of profit and loss position of the company happened to be, would be undermining that. And we do know that, I don't know if even in McKnight whether or not there was a specific section that he said, because he was talking about the stock exchange rules, I think, in McKnight. So I don't know if he tied it to a particular section of a statute that allowed those rules to exist. So I think you can look at it a little bit more widely than saying there must be a section that levies a fine. That would be undermined. I think, as with the stock exchange, if you have a regulator which is entitled to impose sanctions, you can then say this sanction is being shared in a way it's not supposed to be shared.
Well, presumably it's not suggested that the fines in McKnight were not lawfully imposed as fines. My Lord's question is a bit different. We're looking, frankly, a bit in vain for a statutory regime that says that these alternative payments are of that nature. You're relying on an FTT decision that relates essentially to the regulator's intention, or FTT finding about the regulator's intention. And that's about as far as it can go, isn't it?
Well, there isn't a section in the statute that provides for these. And I do think we can, I think there's also the general statement that it does that when you ask why a cost has been incurred, it doesn't normally, if the person to whom you are supposed to pay this liability tells you to don't pay me, pay someone else, it doesn't normally change the nature of the payment.
Yes, but that is, with respect, that is different to what's happened here.
Yeah.
This is, the regulator had to be very careful to say that these payments were not penalties because the legislation requires penalties in terms of the Electricity Act to go to the Treasury. This isn't simply, I owe you money and I tell you, and you tell me to pay it to Lord Justice Snowden instead.
I think we would say that the principle that is identified in McKnight, that such payments, he says fines and penalties, then he explains why. The particular character of a fine and penalty is that its purpose is to punish, and the policy under which that punishment is imposed be diluted. We'd say applies to a settlement of this form, where the regulator, who, though the First-tier Tribunal expressed some doubt about it, there at least a statement about their policy was that these are not to be looked at as purely commercial settlements. Their exercises in its regulating power, has said this is the penalty to which you are exposed. We expect you to concede that, and we can talk about where that will then go. That it does undermine their ability to punish if you can then get somebody else to bear part of that cost.
Why didn't they just impose the whole lot as penalties?
Because they didn't want it all to go to consolidated fund. The impression is that they felt it would be more useful in their purposes for advantaging customers to have systems like this. But I don't think the correspondence suggests that any of this should be looked at as a reduction in the punishment to which the taxpayer faced. There were discounts for early settlement. There was not another discount for agreeing a redress package. I think that those are my submissions on that. Unless you have any further questions particularly on the division between compensation and non-compensation.
Okay. Thank you very much indeed.
think you wanted me to say something about consumer redress orders.
Well, yes, I mean, it's something I have to say, I have been puzzling over it, and my lady drew attention, as I would as well, to obviously what the regulator itself has said by way of its own guidance as to what it thinks it can do. And so I at least ought to give you the opportunity, I think, to say what you feel you can say or want to say about where the power comes from to make the sort of orders, enter into the sort of agreements that were entered into in the current case.
Okay, I think these are two different questions. Really.
There are. Sorry, I wrapped them up.
Looking at consumer redress orders, it seems quite clear from the guidance that the regulator believes. I'm looking at page 286 of the bundle.
Yeah.
This is in the guidance. Before then, there has been a general discussion, which I think overlapped between the redress orders and the penalties, about the factors to take into account.
Yeah.
Although they did seem to be emphasising the detriment in relation to the redress orders rather than the other factors. But when you come to paragraph 6.4 and following, one thing seems clear, that the authority believes that it will only make redress orders, it can only make redress orders where it is identified and calculated consumer detriment. Now that doesn't mean, as I explain later, that doesn't mean individual detriment. It could be global detriment,
Yeah.
which I explain later in 6.5, 6.6 and 6.7. But the key theme of consumer redress orders seems to be that there is consumer detriment and that you are making that good. And if you look at the helpful Annex 1, which is a flowchart, it sort of emphasises the difference. Because step 1 is calculating the detriment or gain and consider making a consumer redress order. Consider whether a consumer redress order is necessary to remedy the consequence of contravention of others. And then you're going to deal with the penal element, the seriousness of the breach, etc., etc. Deterrence, discount. And then they add them together in step 6, but I think that is only for the purpose of ensuring they don't exceed the 10% turnover limit, because that applies to the aggregate of the penalty.
I would read it as saying they have to consider overall
and overall as well. I think there's two things, yes, the overall reasonableness of the penalty, but also to make sure it doesn't actually exceed the 10%, the hard limit that there is on these two. But then, having done that, they then make the appropriate orders. So they might make a redress order in relation to the detriment, I would suggest probably, and the financial penalty to deal with the other matters.
But they are
seems to be the way they're thinking about it.
Potentially looking at them together. In other words, rather than say, if the facts of this case happen today, and they were thinking about a consumer redress order, that might relate to, say, part of the 18 million.
It might, and it might relate to what became the 500-odd thousand. And they might make these orders separately from the penal orders.
Although they're clearly looking at them together, no doubt need to.
Well, they look at them together for some purposes, yes, but I'm only looking at the guidance, but they do seem to draw a fairly clear distinction between the detriment, which seems to be the subject matter of the redress orders. Although it might be global detriment, and it might be dealt with, they suggest, by payments to charity, for instance, if you cannot calculate, it's administratively impossible to calculate.
It's quite clear that the authority thinks that it has the power to make a consumer redress order which will benefit people who suffered no detriment individually, either because they are a charity or because they are people who fall within a statistical class, and the assessment of detriment has been done on a class basis.
But there still has to be a detriment.
But there has to be
identifiable, calculated detriment.
Some estimate of detriment.
Estimate, yes, a calculated
detriment.
Yeah.
I mean, they've,
exactly.
They seem to say so. They seem to think that it's not purely compensatory, or at least it may ultimately benefit people who haven't suffered loss and therefore ergo can't be compensated because they haven't suffered any loss. It may not, presumably, benefit and compensate some people who have suffered loss because they may suffer more than the statistical average, but they're only being given the average payment. I
imagine that would be shared with, for instance, very large group litigation claims where I think that kind of thing sometimes is done.
Yes,
you can't determine.
I mentioned it yesterday in the competition field.
It's still compensatory though, because in principle, anyway, even though some people will be getting money that they didn't lose.
Compensatory.
Because otherwise you couldn't do it in the High Court.
It's compensatory to a class which is specifically permitted by statute.
Yes, but that's different in nature, certainly from the £73, because there was no computation of detriment at all in that case. It wasn't. They weren't saying you suffered detriment of 17 million. We're going to split it up £73 each because we can't work out how much you each got. It's a different nature from that. I would
tell me how you think that was justified then under their statutory powers, which we're going to. You started with the guide.
Yes.
So let's see whether.
Well, what they did in the past, and what maybe they still do to some cases, is justified. I think I understand by the 27A, where it says in all the circumstances, and one of the circumstances they can determine the penalty is the amount that's been agreed will be paid. That is, as I understand it, how they would justify it in statutory terms.
But if that's right, you're saying all the circumstances in deciding how much to penalise somebody allows them to take into account something that is purely voluntary.
Well, voluntary in the sense that you can choose that or the penalty. Yes. It's not voluntary in the sense that you can choose not to pay it at all. You can choose to pay it in this way, or it will be imposed on you by way of penalty. I'm talking about the old regime, not this one. Yeah. That's what happened. And if Scottish Power hadn't agreed to this,
they would have had the penalty. The bald answer to the question. Sorry, I'm saying right or wrong. The answer to the question is it's the words "in all the circumstances" in 27A1.
Yes, that was something I think we discussed yesterday. In fact,
and you say that's the wording, or that's the part of the statute that would be undermined if, in other words, that there are other circumstances that
it's the ability to do that, which we're assuming for these purposes is valid. Obviously, it might not be, but no one's challenged it. So we're assuming that this is a valid intra-vires exercise of their powers. So we have to assume that they have a power to have a situation where they will say to a company, we're minded that a penalty will be whatever it is, 18 million, 23 million, 18 million with discount, but we will agree with you that you will make payments of 18 million in particular ways. We'll impose a £1 penalty because we can take account of the 18 million that you've paid in determining the value of the penalty. But otherwise, the penalty would be 18 million. That's what the notice is. In my submission, that's what's underlying these notices. That's what they're saying. They're saying, looking at the seriousness of everything that happened, or whatever, the appropriate penalty is 23 million with the discount to 18 million. That's what we've calibrated it as, and we're saying you can pay 18 million to whatever, we agree, and you'll get a £1 penalty. And the assumption of all of this today, this case, is that that's valid exercise of power.
I'm not suggesting that it isn't.
No.
What I was probing for is to try and understand where the statutory authority for it comes from, assuming it to be valid. And I think your answer is it's inherent in the words in all the circumstances in section 27A.
Yes, they can impose a penalty of an amount.
And you say that is the part of the statute which has within it a legislative policy which would be undermined if you could deduct whatever that means.
Because one of the things they can do, one of all the circumstances would be this particular kind of agreement that they come into. Obviously, there are other circumstances, and that's why they were looking at the seriousness of the breach and things like that. Those are all obviously also circumstances they take into account.
I wonder if this puts too much emphasis on that phrase "in all the circumstances," because it doesn't enable you to distinguish between the case we put yesterday and the case you're positing. Case one is that the taxpayer has breached its regulatory obligations. Let's say claims handling, and let's say it chooses to make, having realised it's done that, make an ex gratia payment to all its customers on this across-the-board basis because it can be so expensive to work out who in particular had suffered loss of £8.5 million. The regulator becomes aware of the breaches and think, well, this is really awful conduct. It's sort of conduct which warrants a penalty. However, taking into account all the circumstances, including the fact you recognised and paid compensation, we're going to impose a penalty of £1. There's no question that the payment would be tax deductible in that case. And yet,
because it's not being made as a...
Well, but it's part of all the circumstances. In the same way that you're saying, it's part of all the circumstances the taxpayer has agreed to pay £8.5 million in this way. So how do you distinguish between the two using those words?
The case that you're positing is a case where it hasn't been paid and incurred as a result of an exercise of any function by the regulator. The regulator has nothing to do with it.
I suppose the regulator starts an investigation.
Well, then we're getting into I can agree, more difficult circumstances. If the regulator indicates to them that if you were to do this, maybe the penalty will be...
I mean, let's not make it even more difficult than it already is. I mean, take my Lord's example. Somebody makes a complaint. Somebody is aware that there's a problem. The regulator says, okay, we're going to investigate. It's just an investigation at this stage. But the regulated entity sort of wakes up pretty sharpish. And before, say, the P word is ever uttered, says, oh my goodness me, we'll voluntarily make some payments. And then the regulator says, well, okay, having completed our investigation, but having regard to the fact that at a very early stage you did this without us having to threaten you, we think a £1 penalty is appropriate.
But I think going back to the question you were asking me, what
I think that
statutory...
the
question you were asking is what was the statutory basis for the regulator entering into these kind of agreements? And which I say is that what it would be, all the circumstances in the case you're positing may well be simply a background fact that's already happened that they're taking into account and deciding the amount of the penalty. That seems to me to be a different thing. It could change the nature of the payment.
Let's take it to the facts of this case. Now, I mentioned this earlier. If you read the documents, at least one of them says, okay, in fixing our penalty of the penalty of £1, we take account, among other things, of 8.5 million or whatever it was, plus all the work you've done to improve your systems. And as I said before, and you confirm, there's no suggestion of any restriction on deductibility of that. That is something the regulator expressly took into account.
But I'm not suggesting that everything... Sorry, in answering that question, I wasn't saying that everything the regulator takes into account in deciding what to impose a penalty is not
I know
deductible.
you're not suggesting that. But the
I'm not even
difficulty,
starting with that.
the reason we keep asking these questions is we're trying to understand what the dividing line would be.
Yes. But I was answering the question, well, what's the statutory underpinning for this
We've
agreement?
moved on from that. We've got your answer to that. That's 27A.
And so that, that's the underpinning. But the nature of the payment is not determined necessarily by that. I mean, that you were asking the question, well, what does it undermine if you can deduct this payment? And that's the answer is the statute. We would say the Electricity Act provisions. But it's a different question as to answer what's the nature of the payment. The nature of the payment in our case is a nature of a payment that is, I'm using this shorthand, in lieu of the penalty, because it is instead of the penalty.
Might it not be said that
These other payments are not instead of penalties.
But might, well,
In any sense, or
it might be said that in the example that my lord gave you, which I sort of tried to paraphrase, of the early acknowledger and payer, that actually supports the regime as you've identified it, because it encourages regulated entities at a very early stage to create a circumstance which will lead to the regulator deciding not even to think about anything other than a nominal penalty.
yes.
And one of the advantages of that might be that it would be able to deduct it for tax purposes. But isn't that good for the regulated sector?
Well, that is. I wasn't. I think in answer to your question, I wasn't saying that was not deductible necessarily. I totally agree with you, but we're not in that position here. They are being forced essentially to make these payments. They haven't volunteered them in any sense. They haven't said we're going to make them whatever you do about penalties. They have actually got to the position where they've got a choice between the penalty and the payment. That's the situation here. So I think in my submission the policy would be different. I quite agree with you. There would be a policy encouraging companies that wake up voluntarily, notice that they're in breach of regulations, to put it right without the regulator getting involved or the regulator forcing them. But that's not the position here. And you saw, I think Mr. Chacko showed you some of the correspondence. I mean, what they were looking for was what the regulator would accept. What amount would they accept? They weren't volunteering these payments. That's a completely different nature. I quite agree with you. If they were volunteering them, if they'd come along to the regulator at the beginning of the investigation and said, look, we'll do all these things voluntarily before you even have to bother about it, then that would be quite a different thing. I would say. So, thank you. I think those are all our submissions.
Right. Thank you very much. Yeah. Skelbrook.
My lords, my lady, having listened to my learned friend, I'm not actually sure what the basis of his claim is for non-deductibility. I'm still not clear whether he's saying it is a matter of statutory interpretation or whether it is a matter of policy or perhaps, as it's put in a rather good Australian film called The Castle, the vibe of the thing. So they don't know what the basis of the claim is. They don't know when the payment becomes non-deductible. It's at some point in the spectrum of its life when it starts in the root of the complaint conduct of not answering the phone quickly enough, or if we pay it before the regulators come, that's deductible. If you pay it after the regulators come, it's still deductible, so long as you do it soon enough. But at some point after that, but we're not going to tell you exactly when, because we don't actually know, and neither will anybody else if they win this case. They're asking for freedom to deny deductions willy-nilly when they disapprove of them. That's the truth of it. And they don't know what makes the payments in this case different from the redress payments made as ordinary compensation, except that the regulator is involved. But the regulator is omnipresent in a regulated industry. So if it is the involvement of the regulator, every payment has some sort of engagement with the regulator, even if it is just to keep him away. So there's a great deal of cloud, difficulty in understanding exactly what the argument is. On any view, the court is being asked to extend what Lord Hoffman said in McKnight. That, I think, is accepted by my learned friend. I think Mr. Chacko this afternoon said something different, but I take it to be agreed that McKnight has to be extended if it is to cover this case, because McKnight is certainly about something which is fines and penalties. But once it's accepted that an extension to McKnight is needed, then it must follow that McKnight is not a binding authority that leads to the conclusion that the payments in this case are non-deductible. Your lordships and your ladyship are being asked to extend the rule, to make a new judge-made rule in an area which the Supreme Court has recently reaffirmed in NCL is essentially a matter where you expect statutory rules. Judge-made rules are not impossible, but they're unlikely. And again, it's not clear what the basis for any judge-made rule would be. When Lord Hoffman refers to the specific policy of the rule under which the payment is made, he cannot be speaking of a rule of interpreting statutes in comity with each other. The penalty in McKnight was a contractual penalty imposed under the rules of the stock exchange. It doesn't appear at the time that happened that there was any statutory authority for the rules of the stock exchange. So Lord Hoffman is contemplating a contractual payment, and it cannot be that a contractual payment of a penalty engages some rule that can override Section 54. So once we've recognised that Lord Hoffman is talking about a contractual penalty, it follows that his basis of his rule is a policy basis, not an interpretation basis. And I submit that if there is a rule of policy that Lord Hoffman is proposing, it's new. And there's no...
To the extent he's explaining Von Glen, I mean, Von Glen was a statutory underpinning for the penalty.
Yes.
So, I mean, it comes back to a point. You may say we're not bound by the decision in McKnight, but if his explanation of a decision of the Court of Appeal that we are bound by, the good one, on the facts of the Court of Appeal case, where there was a statutory underpinning, then we're still bound, aren't we?
Yes.
To the extent...
Yes, but then, of course, these are different payments in this case. They're not fines and penalties.
Well, hence the search for the statute, which underpins them.
Yes. Well,
and you'd say if you don't find a statute that underpins them, then the taxing statute can't be prejudiced by the deduction of the payments.
Yes, that's what I do say.
Sorry, the other way around, I meant. Sorry. There is no statute to be prejudiced by the ability of the taxing statute to allow deduction. Sorry,
I understood your lordship to mean that. Then next, Lord Hoffman is in any event not laying down a hard and fast rule. He says non-deductibility depends on the nature of the expenditure and the specific policy of the rule under which it became payable. So by doing that, he allows scope for an evaluation which accords more with the approach actually adopted in Von Glen, which was to look to whether the payments were commercial or not. Now, my learned friend criticised my use of warns yesterday. First of all, he said it's a case about what became Section 130E, now 54.2, rather than
54.1b.
54.1b, rather than 138, 54.1a. But in McKnight, in the Court of Appeal, it was accepted that those two rules have the same meaning. You can see that in the report of McKnight that we handed in as a supplementary report in the Court of Appeal. It's on page 851 of the report, at letter J at the bottom of the page. And I think it's generally accepted that the two rules impose the same test. And then if we look at Von Glen, tab 3 in the authorities bundle at page 63, says it's perhaps a little difficult to put the distinction into very exact language, but there seems to be a difference between a commercial loss in trading and a penalty imposed upon a person. So there he is adopting the commercial language that Mr. Justice Rowlatt used in Warnes just before he upholds Warnes. And page 66, about the middle of the page, not a commercial loss, and I think when the Act speaks of loss connected with or arising out of such trade, it means a commercial loss. So the Court of Appeal thought it was interpreting the words of what is now Section 54 to require a commercial payment. And in our submission, that is not inconsistent with what Lord Hoffman is saying when he says that you have to take account of the specific policy of the rule. And in our submission, once allowance is made for the nature of the expenditure, its inherently commercial nature as compensation must be recognised. That is the deal that the parties did. And my learned friend has addressed you on the basis that there was a penalty imposed before the settlement agreement was reached. But that is not the case. And if we look in the supplemental bundle at tab...
Sorry, can I just pause, just something you just said? I mean, I understand why it might be said that Scottish Power thought it in their commercial interests to enter into this agreement rather than tough it out and be subjected to penalties and then going through an appeal process, etc.
Yeah.
One of the distinctions we've been asked to look at is the distinction between compensation and something that is not compensatory.
Yes.
And if a payment which is agreed to is not compensatory in any identifiable way, what do you say about that? Because I think what you just said was that it's perfectly commercially sensible for somebody to pay compensation arising out of the relationship with the consumer. But what happens if they pay something which isn't compensatory, but which is?
Well, I'm saying this is an inherently commercial payment, whether you classify it as compensation or not.
Right. So the emphasis is not actually on you slipped in compensation. You're saying the emphasis is whatever the constituent elements, is it made for a commercial purpose?
Yes. Yes. And I've adapted that from what Mr. Justice Rolat said in Warnes. Is it contemplable? One feels it ought to be contemplatable, but that's not in the dictionary. And we know it's contemplable because Scottish Power makes these payments all over the place. They're referred to in some of these documents. So if we look at tab 20 in the supplemental bundle, it's worth noting that it's headed without prejudice and subject to contract. The point being that they only ever agree and are only ever subject to an agreement to make redress payments of whatever the number was and a penalty of £1. That's the deal that they did. An HMRC should not be allowed to tax on a basis that the payments were penalties when the matter was advertised to the world on the basis that the redress payments weren't penalties. Not only advertised to the world, but went through a consultation process. And there is a document at Supplemental Bundle tab 9. Can you
the laptop out.
well, we have a larger print.
That would be helpful. Otherwise, we're going to definitely all resort to laptops.
Now, the point to get from this, at the bottom of page 185, there was a discussion this morning as to whether there could be a penalty of 0. And what the last two lines at the bottom of page 185 say is that Ofgem has done that in a number of cases. Not very many, but it has done it. And you can see in this document some quite interesting insights into why the parties were doing what they were doing. And certainly Ofgem are referring to deterrence.
Just before you get to deterrence, I see that just over the page, the sentence following the one you drew our attention to does support Mr. Ewett's point to us that, I think it may even be my lady's point to him, that one of the purposes was to trigger the representations regime by having a £1 penalty.
Yes. Yes. But representations into the £1.
Yes, yes. Well, £1 in light of all the circumstances.
Yeah.
Sorry, I took it out of your way. You were going to show us something else here.
It doesn't refer to punishment. And there are 3 emails here. So I've just taken one bit to respond to something that was said this morning. But I note that when they talk about in lieu of financial penalty in these emails, they put that in inverted commas.
Where do they put that?
It's in the email at the 4th of January on page 186.
Oh, yes.
So there's a Scottish Power didn't want to pay the £1 penalty. And so this correspondence says, don't charge us the £1. So the email at the bottom of page 186 is from Scottish Power to the regulator. The email starting at the bottom of 185 is from the regulator to Scottish Power. And then there's a reply at the top of page 185. This also shows that the parties were negotiating over what was to happen. And if we look at the FTT's decision at paragraphs 37 to 39, we can see how the negotiation went. 38, you see, negotiations followed. Ofgem suggested a significant penalty. Towards the end of 2011, discussions came close to agreeing a settlement payment by SPEL of 17.5 million. The amount exceeded SPEL's estimate of the consumer detriment caused by its actions, but SPEL contemplated paying it to bring the investigation to an end. The negotiations broke down because SPEL didn't agree with Ofgem's desire to include a £1 penalty, in addition to the 17.5 million settlement package. Then negotiations later resumed, and SPEL agreed to pay 7.5 million to vulnerable customers. So these agreements are extremely valuable to the regulator, as your lordship was suggesting, in achieving settlements. And you cannot say, as my learned friend says, oh, they've agreed to pay 18.5 million and now we're dividing it up. That just isn't what was happening. If they had carried on debating, who knows what numbers we might have got down to. So the suggestion that there's an absolute certainty in these things is fatuous. And generally, it is the duty of the regulator to further the interests of the consumers. And that is what it is doing when it enters into these agreements. And actually, it ought to be encouraged to do it, not denied deduction. My lords, my lady, unless I can help you further, there is my submission.
Thank you very much, Mr. Goldberg. Miss Inglis, I'm very sorry, I have an apology, which I didn't ask you earlier when Mr. Goldberg opened the matter, whether you wanted to add anything at all. And given that in this day and age, junior counsel, I think, should have that opportunity, which Mr. Chackle took full advantage of. Is there anything you wanted to add?
Nothing to add, my lord.
Right, thank you very much. And we've obviously seen the skeleton arguments, which I'm sure you contributed enormously to. Right, well, thank you very much, everyone. It won't come as any surprise to hear that we are going to reserve judgment. I can't promise, and I won't promise that it will be with you before Christmas, but doubtless we'll do our best. It'll come out in the usual way, in draft, and I'm sure that you're all well aware that it comes with an embargo. The draft is for the purpose of giving us corrections and any obvious errors, but nothing more than that, and the embargo means what it says. So it'll be shown to only those who've given us their, should only be shown to those who've given us their names in advance. Thank you very much indeed, and that concludes the hearing.
All right.